You got light in you this morning, don't you?
I don't know why. I'm just trying to, I don't know what I'm doing. I never do. Good morning, everybody. Welcome back, Law and Legitimacy. It's Thursday. We've got a winter weather advisory up here in northern Vermont. We're told to expect 4 to 6 inches of snow this afternoon. That usually means a foot up my way. I'm way up in the hills here near a lake, and I do believe in lake effect snow. So I'll be out battening down the hatches a little bit later today, making sure I've got enough food and whatnot in case I can't get out of here for a few days, because that happens too. But you're back and you don't want to hear about my weather related woes. You want to hear about Fani Willis. Today's the day. There she be. How a tattoo on Fani Willis or her boyfriend or both could end their time prosecuting Trump. What's all this about? So Fani Willis, as you know, is the prosecutor in Georgia, Fulton County, who set her sights on Donald Trump and a number of his associates in an ambitious state RICO prosecution, claiming that their attempts to interfere with the Georgia election results is tantamount to racketeering. And so she's got her sights set on trial for them. And one of his co-defendants, one of Trump's co-defendants, represented by a woman, I think her name is Ashley Bannon, filed a motion to disqualify Fani on the claims that she and Nathan Wade, the principal prosecutor she's appointed to handle the case, have either an actual conflict of interest, or a seeming conflict that creates an appearance of impropriety in the form of a relationship that was formed prior to the prosecution of Trump.
Ashley Merchant.
Ashley Merchant. Thank you. I don't know why I thought Bannon, but Ashley Merchant. She got the highest praise, I think, in the New York Post. Was it yesterday or somewhere? They said, "Meet the badass lawyer." So unlike some of the lawyers in the Trump orbit who've been trashed and crashed and burned as a result of their association with the case, this lawyer is on the way up. Pay attention to her. So Ashley Merchant. So the claim today is going to, and so Fani so there's a hearing today in front of the Fulton County judge, who's going to hear evidence on whether there is a conflict or the appearance of a conflict that should disqualify Fani. Here's what Ashley is going to attempt to prove, and that is that there was a relationship that predated the appointment of Nathan Wade to the prosecution team. And Wade, by the way, has no felony prosecution experience. He's a civil lawyer. So just why did Fani tap him? Why did she tap his bones? Well, maybe she was tapping him in more ways than one. So he's got the job, and now some $650,000 or $700,000 later, he's out there churning the file and pushing paper against the Donald, while taking Fani on some fancy trips, paying for those trips out of the largesse that the state of Georgia is paying him to prosecute Trump. So this raises the question whether she is receiving a financial benefit from the prosecution of Trump. On the one hand, it's a thin claim, meaning, okay, you went on a few trips with your squeeze and he bought you some flowers and an airline ticket, and maybe took you on a cruise. That's not exactly living high on the hog, but it is something, and it might be enough to disqualify her. She's fought this in all the wrong ways. First, she resisted subpoenas, saying that this was a political witch hunt and a stunt, and she shouldn't. The dignity of her office was such that she shouldn't be compelled to respond. And the court said, no. You're a public servant, Fani, and serious questions have arisen, and you're going to answer them. And then she denied that the relationship with Wade predated his appointment. And this is where the rubber starts to meet the road, potentially, because if it can be shown that she lied in her responses, that is, that she tried to cover or dissemble about her relationship with Wade, she's suddenly on the defensive, and she's looking less like a minister of justice and just like another chick caught in the arms of her achy breaky heart boyfriend lover in the midst of another divorce, Nathan Wade. She's also played irresponsibly the race card in this. She appeared at a African Methodist Episcopal church not long ago to say that she was the focus of this attention. She's not perfect, hint, hint, echo, echo, Martin Luther King, but she's doing, she's marching in the triumphant arc of history, and she's going to bring the Donald down. I don't know. She didn't look like Martin Luther King to me. She looked like an ABC. What's an ABC? An angry black chick. Somebody who's just
I thought you
decided.
were gonna say anything but competent.
Yeah, well, that too. Maybe that's why.
So, Norm, I can't believe you spent all this time talking without getting into the rules of evidence and the potential admissibility of the alleged tattoo that
Well,
she.
I was getting to that.
All right, awesome. Well, let's do that.
All right, so that's Mike's way of kicking me in the ass and say, "Stop dribbling into your oatmeal, old man, and get to the point." So, a pivotal consideration today will be whether Fannie or Wade got a tattoo. Merchants got a receipt of $74 for something at a tattoo parlor in March of a given year, prior to Wade's appointment. And this is a year the two of them were believed to be at a location together. What's that tattoo say? Does it say "Forever Fannie" or "I'm wading into Wade"? Do they both have they both have tattoos, or is it just one? Can they be compelled to show it? So let's talk about the rules of evidence. Normally, a person cannot be compelled to give evidence against themselves if that evidence is going to tend to show that they're guilty of a crime. That's the Fifth Amendment privilege. No one is accusing Fat Fanny of a crime here. They're accusing her of impropriety. So what would happen if she tried to take the fifth? It could be challenged on grounds that there was no criminal exposure. Courts typically tip their hat or head in the direction of granting Fifth Amendment privileges. It is so vital. But showing a tattoo might not be subject to the Fifth Amendment at all. The Fifth Amendment is a testimonial privilege. In other words, you cannot be compelled to give evidence against yourself through expressive conduct, through speech or communicative conduct. And so, for example, she couldn't be asked, if the fifth applied, she couldn't be asked questions about the tattoo. She couldn't be asked to select it. She couldn't be asked for documents that tend to show where she was that day. That would be the act of production, Fifth Amendment. And her lawyers could claim that to the degree that selecting documents in response to a subpoena requires communicative work, requires interpretive work, requires expressive work, this act of production, Fifth, would violate her Fifth Amendment right against producing evidence against herself. But she can, and this is where it gets a little difficult, she can be required to show her ass. I mean, let's just say that tattoo is on the left cheek of Fanny. Could the court say in some in-camera proceeding, "Show us the tattoo"? And the answer is yes, because the court couldn't say, "Show us the tattoo you got in March," because that act of showing it would reflect that she was acknowledging she got the tattoo in March, and that would be covered by the act of production Fifth Amendment privilege. But if they had ideas that she had a tattoo, they could say, we're going to ask you to take a picture of any and all tattoos on your person. They could do that. And so, for example, prosecutors can compel bite mark impressions. They can compel handwriting exemplars. They can require a person to stand in a lineup for people to identify them, a so-called show up. Efforts have been made to argue that these are covered by the Fifth Amendment, these activities, but they're not expressive activities per se. Those physical activities are not covered by the Fifth Amendment. So Fanny's tattoo will be central, or Wade Nathan's tattoo will be central to the proceedings today. The question will be, was that tattoo inscribed on their body prior to the time she says the relationship formed? And if so, what were they doing in a Caribbean location getting a tattoo? And frankly, what I want to know is what the tattoo says,
Well, it's also, I mean, look, I don't know if I haven't heard anybody take this angle on it, but I'll just throw it out there. Tattoo parlors double as piercing parlors as well. So it's possible that when they were in Belize, a 70-something dollar charge might not go a long way in the ink world, but it might do something sufficient for some sort of piercing that is, maybe from the neck down that
wow.
anybody know about as well. So, then she would need to then it could get really interesting. There's a couple of one question, and then also just a general, I guess, sense of irony that I like to bite on here. And I'll start with the latter. In this New York Sun article, A.R. Hoffman, I want to make sure I'm getting his name here correct. Yeah, A.R. Hoffman. I love his writing. One thing he points out, and this is also a case that we have covered very, like, sort of at a surface level, but recall the the prosecution of a different racketeering case by
Oh,
Fani Willis,
yeah.
Georgia, of Young Thug and the YSL gang, and it is being reported now that at least one of the alleged members of that YSL gang has gone on the stand and been asked about his tattoos by Fani Willis and Company as prosecution. So just a general bit of irony there. One question for you, though, Norm. When we assess the sort of probative value of a piece of evidence in the context of admissibility, and we're also looking for some sort of prejudice on the other side, when it's a court kind of holding a hearing in this instance, how do the rules of evidence as generally applied get suspended or otherwise muted?
Well, I mean, in theory, the rules of evidence never are suspended, but a court's application of the rules is evaluated on appeal in the so-called abusive discretion standard. In other words, courts are given great deference to the decisions they make on application of the code. When trying to introduce a piece of evidence, the proponent has to persuade the judge that the evidence is both material, that it matters, that it tends to the case at bar, and that it's relevant, that it has a tendency to show a disputed issue. So in this case, Attorney Merchant will ask the judge for a ruling permitting her to put the tattoos before the fact finder because the tattoos are material to when the relationship was formed, which is material to whether there's an appearance of impropriety, whether Fani is getting some financial benefit from appointing her lover to the prosecution. Indeed, whether she appointed an otherwise seemingly unqualified man to the prosecution because he is and was her lover. And so that tattoo, together with other evidence that they were in a Caribbean island at the time that it was imposed, or this piercing, and whatever communicative content that has, I think is both material and relevant. When a proceeding is tried to the court, that is, when the fact finder is the judge rather than a jury, judges are presumed to follow the law. And when on appeal, a party wants to say a judge abused his or her discretion by admitting a piece of evidence, it's harder to prove that in a court trial, because even if the ruling is screwy, the judge is presumed to be a disciplined fact finder. And so an otherwise very deferential standard, the abuse of discretion standard, which defers to a judge's ability to admit evidence. In a court trial, it's almost an impenetrable burden on appeal to say that that was error. Now, Fani may claim, let's say Fani's tattoo is on her fanny. She may claim that it would be humiliating and a breach of privacy for her to have to drop her drawers in a televised hearing.
Then just step aside.
Yeah, then she's right. They'd go into a side room and take a photograph, or the judge could inspect it in camera. There are ways to work around that. So the bottom line is, interesting events in Fulton County. I don't think this is going to derail the prosecution of Donald Trump down there. If Fani and Nathan are removed, others will step forward. And of course, that will accomplish the objective that the Donald wanted, which was delay until after the November elections. So stay tuned on that. Hope you learned a little something there about the Fifth Amendment and its application. Remember, it's a testimonial privilege. It's not a barrier to producing items unless the act of production has communicative content. So a prosecutor can't ask you to go get every email that's relevant to this bank transaction, because then you're deciding what's relevant. But if the prosecutor says, give me your emails from such and such a date, that's a different question. And so that's the needle that will have to be thread in Fani's fabulous Fani-ridden case in Fulton County today. What's up in Florida?
Well, I'm blown away by this story. So we've got a young gentleman here by the name of Dylan Brewer. He's 19, out of the Tampa area, and he's been arrested. He turned himself in to the Delray Beach Police Department for, among other things, charges related to vandalism in excess of $1,000. I guess property damage, and then also there's a felony enhancement for some sort of hateful motive here, Norm.
Mhm.
And the basic facts are that he that he took his truck and, as you see on the screen there, did an extended burnout on a LGBT pride crosswalk there at the beach and at an intersection. And apparently, resources of the police department, Norm, were allocated for over a week. They were trying to build a case on whomever this might be, receiving tips from, videos from, random observers, et cetera, et cetera, et cetera, and pressure mounted. And he just turned himself in and he's been charged. Big win for the police department here.
I guess. I mean, so he burned his rubber on a gay pride street whatever mural, and this is a felony that is.
It was just a crosswalk painted as the pride flag color.
Yeah,
Right.
I don't know. I don't know. I mean, I remember when I was a kid in Detroit, burning rubber was a big deal. Kids who were lucky enough to have a car, and they didn't. Of course, we didn't have pride logos on the street. I just don't see. I don't see this as anything other than a public nuisance. The notion that it should be treated as a hate crime and he should potentially face conviction for a felony for this.
Here's the police department statement. Quote, the reckless action caused significant damage to the streetscape painting, which serves as a symbol of unity and inclusivity for the LGBTQ community.
What if he was just driving along and he said, I don't want to have somebody's sexuality driven, pushed into my face.
That's right. That's the correct take, Norm. In my opinion.
My view is, I mean, I'm not asking you, Mike, whether you like the missionary position or not. I just don't really give a damn. And I don't want to, and I don't want to be walking down the street and told that, hey, it's time for you to respect my libidinal preferences or my sexual orientation. How did that happen? How did we as a society decide that somehow everybody wins a prize and that we've got to recognize everybody's idiosyncratic quirk and give public homage to it? And if a person just says enough, I don't want to hear it, and expresses some disgust, they become a criminal? How did that happen?
Well, look, here here we are in the free state of Florida, wink, wink, where we attempt to pass laws that would need to credential journalists, and then also have local police departments and municipalities protecting the theme of unity and inclusivity of a fucking crosswalk. Pardon my French, but that's sort of the issue here, is that it is in all I guess meaning that we can see at this point, Norm, more emblematic of a religion, of some sort of state sponsored cult to a certain degree. And that's even overlooking the fact that his tires indiscriminately shed rubber all over what is a monolith of LGBTQ plus whatever. But we don't necessarily know if he had one specific group within that larger monolith in mind or not, right? Perhaps he's fine with the L's, the G's, and the B's, but maybe it's T's, or maybe it's Q's, but
or maybe it's just the others, or maybe it's just this sense of exhaustion. I'm reading another book that I nerd alert here, guys. You get the impression I don't sleep much at night. You're right. American White Lash, A Changing Nation and the Cost of Progress by Wesley Lowery. His perspective is that somehow people like this young man are white lashers, that as the world verges toward inclusivity, there are those who are inspired by hatred because they're losing a sense of supremacy, white supremacy in this case. I think Lowery is wrong. I think there's just a sense of exhaustion and fatigue, and that if you happen to be white and you happen to be a male, everybody else's desire suddenly to be recognized and demand that their ring be kissed is a form of moral exhaustion that yields a sense of repugnance. I just don't want to hear it anymore. So I don't view this kid as a white supremacist. I don't view him as engaging in hate speech. I just say, I think what he's saying is, I just want to drive down the road without somebody trying to have my consciousness raised.
That's right. That's right. T-Girl says on Rumble, which I love this, maybe don't paint your feelings on the street.
Absolutely.
And that's a great way to look at it. But also, he's 19 years old, right? Yeah. I mean, think about being in a truck at 19 and being proselytized day in, day out about the way you should think, the way you should be, certain suppositions about your character based on your own immutable characteristics, etc. And this is such a small act of defiance. If you can even qualify it as that. I mean, a a burnout is as American as apple pie, right? And so for this to be, made into something where he's got to turn himself into the police is insane. Dawn
It
asked
sure is.
a good question. I think there's an important distinction to make here, Norm, but I do want us to address this because you have talked about I guess, the threat of a hate speech exception to the First Amendment being a development that you are
Yeah,
I guess.
I'm going to turn to Dawn's comment in a moment, but first I want to put out a plea for help. Anybody who knows Junior Coltrane, he's going to be needing a divorce lawyer soon. I believe Junior's on the West Coast. He writes this morning. He's trying to talk his wife into getting a face tattoo of a pretty woman. So again, if you're a divorce lawyer and you know Junior Coltrane's jurisdiction, give us a call. We'll hook you up. He's going to be needing you and soon. Junior, shame on you. You've been listening to Law and Legitimacy too long. Dawn McNeil, are the concept of hate crimes and hate speech legally valid or just forms of social control? So in a crime, what is a crime? We have statutory penal codes in the United States, meaning legislatures define what crimes are. We don't have a federal common or state common criminal code. Basically, they're not judge-made rules, they're statutes. And so hate crime statutes add an element to an offense that must be proven. So, for example, assault might be, or battery might be making physical contact with somebody with the intent to do harm. And then the degrees of assault would reflect the amount of harm done. First degree assault, intent to cause serious physical injury. Second degree assault, cause injury. Third degree unlawful contact. If you want to make that into a hate crime, you add an element on account of a person's identity. They do so out of disapproval for a person's identity, whether it be because they're LGBTQ, white male, woman, black, Mexican, Hispanic, alien. It becomes a hate crime when the motive is inspired by disregard or disgust or opposition or hatred to the other person's identity. These hate crime elements typically serve as enhancements, adding mandatory minimum time or prison time to an offense that already existed. The courts have upheld these as lawful assertions of legislative power. Attempts to have them declared unconstitutional or inapplicable have not worked thus far. Hate speech is something altogether different. Hate speech can be evidence of a hate crime. I punch a person because I hate white, there's another white man. Bam! How's that feel, cracker face? My speech is circumstantial evidence of what motivated me to punch, but it's not independently actionable, at least not yet. Hate speech as a category of speech is speech that doesn't really have a definition, but I'll offer one here just to advance the discussion. It's speech that reflects hatred or disgust or disapproval of a person on account of their perceived identity or who you think they are. And so I think there are efforts across the country to try to criminalize hate speech, saying that the thought is the father of the act, and if we can cripple the thought,
I don't even think it's that deep, Norm. We've seen outward expressions of speech is violence, right? The equating just a verbal act to what one would consider the same as a physical assault. Right?
No, I think that's true, but we're not there yet. And here's my fear. Here's my prediction.
That's why I wanted to make the distinction between a hate crime and what we, I guess, in modern parlance talk about when we consider hate speech. Two completely different things, historically speaking, right?
Well, so the crime is the action, the speech is the thought. Thoughts aren't crimes, at least not yet. And I think that, let's consider the case of obscenity. So, if you have a nude picture of your grandchild at the summer pool and you send it in the mail to one of your family members and it's intercepted by the postmaster, is that distribution of child pornography? I mean, it is a picture of a naked child after all, and it's sent to someone else to satisfy them. But we say of those sorts of pictures that they have sentimental and social value. Similarly, a book like Nabokov's Lolita, while glorifying pedophilia, it does so because for serious artistic and literary, it has serious artistic and literary value, at least in the eyes of critics and mine as well. That which is obscene lacks any scientific, serious, literary literary, scientific, or educational value, and is done simply to appeal to a person's prurient, or that is base instincts. And there are community standards on what constitutes obscenity. Here's my prediction. While speech in the United States, especially political speech, has always been valued under the so-called marketplace of ideas analogy, I think there's a tendency right now to want to say that some political speech lacks value because it's disinformation, misinformation, or hate speech, or is so far from the norm that it cannot be tolerated. And so there's going to be an effort to graft the obscenity standard into political speech. And that case will reach the United States Supreme Court probably within the next 10 years, in my opinion. We're not there yet, but Dawn, there is a significant movement to criminalize hate speech. And I think to the degree that we tolerate censorship, or we call for regulation of misinformation and disinformation, to the degree that we become comfortable with government regulation of the content of speech, we're one step closer to hate speech.
Man, I'm thinking now with you sort of predicting the future as
Newsflash, Mike is thinking.
Yeah.
What does it look like when Mike thinks? Zoom in, thought bubble. Mike, what up?
I'm thinking about Western Europe, in particular the UK, and what we're witnessing over there is almost a litmus test, or one of those canary in the coal mine examples of how speech is being criminalized, and what we may expect as its manifest destiny, as that sort of zeitgeist moves westward into America. I know that we're watching state governments and city governments attempt to regulate social media and get involved in using some sort of public health justification for that. I've been highly critical of the state's ability to even understand what's going on from a neurological perspective with respect to the tools that are being deployed against young people via the algorithm and via these devices. But it seems obvious to me that that censorship is almost programmatic at this point. If there's any sort of outward censorship, that is sort of a last resort. It occurs to me that in today's day and age, the art of censorship is censoring thoughts before they are expressed.
It could be. And, where will we see this battle line get drawn? There was an interesting story this morning. Apparently NC 131, which is a neo-Nazi group in New England that strives to create a white ethno-state in New England. Apparently this group protested outside the governor of Massachusetts' home, I guess last night. The NC 131 is called a white supremacist group. It is called a purveyor of hate speech. And so when they appear to protest outside the governor's home, they draw attention to themselves. And they appeared in masks, and they looked a lot like at least according to the press account, it felt a lot like the Charlottesville rally in 2017. And we saw where that led. People who turned out at that rally and protested were deemed to be white supremacists, followed, and then mercilessly prosecuted when they acted out in public. I think of the Proud Boys, for example, and their treatment in the January 6th insurrection prosecutions. NC 131 are people who, much like this young man in Florida, I think, are fed up with the shape of the world as it arises, and are tired of being told that when they're tired, they must reach in more because they owe the world, they owe others regard, and they're tired of being told who they have to regard and how. And so, here's the story. Neo-Nazis swarm home of New England governor. This is the governor of Massachusetts, who recently appointed a former lover of hers to the Supreme Court. I mean, people read these stories and they're like, hey, what's up with that? And then they appear to protest and they get smeared. Now, I don't know enough about NC 131. I don't know NSC 131.
I don't get confused with NC as in North Carolina. It's not.
Aren't you guys neo-Nazis in North Carolina?
I guess depending on what day of the week it is.
I mean, Angry Dog, Angry Dog, who's back today, apparently took his birthday off. If I'm Angry Dog and my birthday is on Valentine's Day, I guess I would lay low on Valentine's Day as well, because how many people would say, happy birthday, sweetheart? Happy birthday, Angry Dog, 73. thanks for checking in this morning. But NSC 131 has caught my interest earlier. They were sued by the Attorney General of Massachusetts late last year under a RICO complaint, claiming that they were intending to target and terrorize people and interfere with their rights. They want to hold this neo-Nazi group and its leaders accountable. Well, okay, hold them accountable if they commit crimes, but are you going to hold them accountable if they're just intolerant of your efforts to impose a DEI agenda on everyone, everywhere, including how we drive on the streets? NSC 131 is not a group that I'm coming to the support of at this point. I'm simply saying it's the tip of a larger iceberg, and it bears watching.
Yeah, I'm watching chatter online as well. There people kind of split on this issue as it relates to sort of the, I guess, Christian nationalism
Mm-hmm.
and, and the expectation that our national security apparatus, that is domestic surveillance, and our alphabet agencies are sort of stoking a what is an otherwise imaginary demon in the form of Christian nationalism, and attributing that group with all sorts of covert operations and painting it as an existential threat to our national unity and sovereignty, blah blah blah, um, as an excuse for more martial law style tactics, right? And there's your book.
Well,
Uh,
that is sort
it
of,
just strikes
what
me as
Wesley Lowery's book kind of gives you the playbook. I mean, if you are tired, exhausted, and fed up by the politics of DEI, then by definition, you're a racist and a white supremacist. If you happen to believe that the United States was a republic made possible in part by its reliance on the Judeo-Christian tradition, you're a Christian nationalist. If you're a white male Christian nationalist, you are a domestic terrorist and you must be silenced. I mean, when did it become a crime to believe in the Bible? When did it become a crime to believe that we are fundamentally a religious people? When did it become a crime to believe that people should be judged by the content of their character, not their various libidinal itches that they have to display in Technicolor across every crosswalk in Florida? It's not a crime. And I think that people who are classified in this group need to fight back. I'm not sure NSC 131 is doing it in the right way. I'm not sure I would support them. But again, I do think of it as a significant canary in the coal mine.
NSC 131 isn't just the latest iteration of Patriot Front, which is largely regarded as being a Fed op anyway, right? So anyway, these things I think bear scrutiny, a lot of scrutiny, as you just said, Norm, especially from those of us who are advocating for positions such as we're advocating. And far be it for me to lack some self-awareness on this issue. I get it. We live in a time where most people are just deathly afraid to step outside, and so tell them to speak their mind or act courageously or believe in, I don't know, certain inalienable rights of every individual citizen that's a part of the union, and maybe step forth into that is a proposition altogether impossible for the average person. But having said that, it doesn't mean that those of us with some wisdom about and some awareness of the tactics can at least do some additional digging. That's all that this ultimately is just additional due diligence. Don't be so complacent as to read a headline and that's it. It really is, send a FOIA request, start going to town council meetings and just listening. Try to understand who is talking about these things in your community, and just try to understand what exactly is motivating that behavior.
Junior Coltrane, according to Pat Clifton, the other angry dog, talks enough shit for 2 sets of teeth. Junior, what happened when we called you out and suggested you might need a lawyer for your matrimonial stuff? Oh, there you are. Okay, you're back. I thought you disappeared. We're running in fear lest the little woman grab a frying pan and seek to readjust your attitude. You want a better looking woman? I want a man with an ass that fries. Wham! Anyhow, we're done for today. We didn't cover what we intended to. We rarely do. And I see one of my good friends is calls me all the time. Spam risk. Goodbye. So
many of those calls now, I wonder if it's even accurate anymore, right? How many calls am I actually missing?
Yeah. So listen, folks, thanks for tuning in. Hey, and if you know anybody in New England, I'd like to interview one of the guys from NSC 131. Hook them up with us. We'll provide them with a pseudonym if necessary, if they're afraid of a blowback. But I want to know what makes people angry enough to go to a governor's house and protest. What are they afraid of? What do they fear? What do they want us to hear? How can we reach out to them the way we reach out to everyone else to build a better community?
We've got Mark Meckler. I think we're going to do a long form live on Tuesday, Norm, at 1 p.m.
We're not doing that today. I had my calendar marked for today.
Oh my goodness! Look at your calendar invites. Good God. Anyway, yeah, that's coming up next week. So if you want to tune in,
did our newsletter get out yesterday?
Don't ask me about that right now, Norm. Please don't ask me.
Our newsletter is coming any day now.
It's like the U.S. Postal Service, you know.
All right.
Anyway, it'll come, but I wanted to at least say that we will have sort of we'll still do our normal stream 8 a.m. that morning, try to keep it brief, and then Mark Meckler will come on at 1 p.m. Eastern time on Tuesday, and we'll do probably an hour or so with Mark Meckler, who you might remember is the founder and leading man of Convention of States out of Texas. And so we'll be talking about the immigration issue, the 10th Amendment federalism, and the sort of the modern consensus around what America is to do about the issue at the southern border.
And, Meckler was one of the founders of the Tea Party, which, according to Wesley Lowery, is another hotbed of white supremacism. I'm going to ask him, do you really believe white people are better than others? And what he's going to say is, no, I just don't believe that others are necessarily better than white people. And the only way to get along is to treat people as equals and stop giving people special points for their special identities. People are tired. That's what explains American politics. Exhaustion, fatigue. Do svidaniya, Vladimir, in case you're listening.
Adios, AMF, yo. I'll see y'all tomorrow.